All right, you guys, welcome to the We Win Injury Law podcast. Another awesome episode wherein we're going to talk about some pretty actually like crazy things that are happening with some recent verdicts. And I don't know if you've heard about them or even know about them, but most people know about the great McDonald's case, right? The hot coffee spilled in the lap. And as we're getting ready for the show today, I'm even thinking to myself, it was like 10 million. I keep saying for whatever reason, I have 10 million in my mind, right?
Yeah.
The $10 million verdict for McDonald's for the hot coffee case. And we're going to talk about that, but it's not 10 million.
Yeah.
And then we're going to talk about the most recent case that kind of, parallels with that, the Starbucks case and the recent verdict that just came down against Starbucks. So it's going to be an awesome show. We're going to deep dive into those two cases, what are similar about them, what's different about them, and how it's relevant to you guys in today's day and age.
I like it. Those are good topics.
So let's hop right in. So we're talking about McDonald's case, hot coffee case. It happened in 1992, but then eventually after litigation and resolution verdict, right, 1994.
So let's set the stage here a little bit. I was 5 years old.
And I'm graduated from high school. So that's why
1992 or 94?
1994.
1994.
That's why 1994 like jumped out at me. Like that's high school.
Yeah.
So I don't know if I remember it because in high school I'm not thinking about what's the most recent verdict and what's happening out there in the legal world.
But you might have heard McDonald's hot coffee. It might have been something that came up because it did make national news, at least the verdict.
Well, at the time, it was a big deal. It was a massive verdict at the time. So let's jump in. This is a woman from New Mexico. This is the McDonald's hot coffee case. A woman from New Mexico, Albuquerque.
Stella Liebeck.
So Stella, who is a 79-year-old woman, is going to get hot coffee from McDonald's. Now, when you drink coffee, presumably you want it hot, right?
Yeah.
Similar to hot tea?
I mean, I'm not a coffee drinker, but I like my hot chocolate hot.
You like hot chocolate hot, right?
You want it hot?
So it's a weird thing because you want it hot, but then what's too hot? But anyways, you want hot coffee. So you want it hot. So she's going to get her coffee, 79-year-old woman. And like a lot of people, they get the hot coffee. And I don't think I've ever gotten McDonald's coffee. So I don't know if if you tell them what you want in it, they do it, or you have to put your cream and sugar in it on your own.
So as I recall in the prep for this, so she had got the coffee, she puts it between her legs, and then she takes the lid off to put in
the cream and sugar.
So it didn't come with that.
Right. So she's putting her cream and sugar between, it's
holding the coffee cup like holding a soda cup or whatever. You kind of hold it in your car.
I do it with my water bottle all the time, right? You're driving with your water bottle between your legs.
She's in her grandson's parked car.
Okay. And
so her grandson took her to McDonald's. That's kind of nice.
That is sweet, actually.
Yeah, I actually kind of like this a little more.
I
forgot that little tidbit.
I think
now what happens?
Grandson's still probably kicking himself today.
Yeah.
Had I not taken grandma to go get coffee.
79-year-old grandma, too. That's a sweet old grandma, no matter what it is. 79 years
79.
old.
Well, most grannies are sweet. I don't know if this granny's sweet. You know what?
For her grandson to take her.
She sounds sweet.
She sounds like a saint.
The reason why is she does her coffee. Okay. Cream and sugar spills into her lap. And we all, if you know the McDonald's story, massive 3rd-degree burns to her genitals, thighs,
skin graft,
and buttocks. And so, which required skin graft, surgeries.
Oh.
And it's bad.
Bad.
Okay. So this is why I said Sweet Granny, because Sweet Granny only asked for $20,000. Now she hires a lawyer.
Yeah.
They asked for $20,000 to cover for her medical bills. That to me says she's a sweet granny.
She's a sweet granny.
She's not asking for a ton of money and not asking for.
And we think of it like she's not asking for near enough.
Not enough. Like $20,000. That's crazy. Yeah. But she asked for $20,000 and they offer her $800.
Brutal.
$800.
Now, doing what we do in the daily, that actually isn't that surprising.
No, it happens all the time, right? It happens today in 2025. But that's a big deal because what McDonald's is trying to do is they're trying to say, hey, we didn't do anything wrong. We served the coffee hot like you want it, right? People want hot coffee. And she spilled it in her lap. So they try to make it sound like Granny was at fault.
Yeah.
And offer $800 to make her go away.
You spilled your coffee on you? Come on.
Right.
I think that was probably the knee-jerk reaction for most people.
So I think this lawyer, like most of us do, say that's ridiculous, right? And maybe there were some discussions back and forth.
Yeah.
Where they offered 1,000 and then they went to 1,500.
Because there are confidential settlement offers that are made back and forth. We don't necessarily have those. We don't know what, but at least the newsworthy portion, in hindsight, it was only $800.
$800. So they file suit, right? Rightfully so. They file suit.
Yeah.
They say, look, that's not justice. So that's not right. And that's not taking some accountability for the coffee being as hot as it was.
And knowing our hospital bills along with a skin graft is way more than
this, Jared. I mean, it turns out
brutal.
And let's take a pause real quick. So the coffee, the temperature of the coffee, right? 180 degrees? Is that what I read?
Yeah.
Is that?
They serve their coffee at 180
to 109 degree Fahrenheit. That's next level hot.
Yeah.
So that's hot coffee.
That's hot coffee.
And obviously the damages, i.e. the injuries, spoke for themselves.
And now I got to know, what temperature does water boil at?
That's a good question. I don't know. What's Google saying?
I know the Celsius boils at 212 degrees Fahrenheit.
Wow. Okay, so almost boiling
hot water.
Yeah, that's gonna do some damage to your skin, right? So the crux of that, though, was once they got into the lawsuit and they did some discovery. Okay, yeah. So discovery. If you guys are out there and you have an injury lawsuit wherever, and you have a lawyer, and your lawyer's telling you, hey, we're kind of in that discovery phase, and they haven't really explained that well to you. Yeah. Discovery is super important because discovery is exactly like how it sounds. It enables your lawyer, us, injury lawyers, to find certain things out, to find information out that can help your case.
We're trying to discover it.
So that oftentimes is in the form of depositions. So if your lawyer says, hey, they want to take your deposition, that's part of the discovery process.
Yeah, they're going to interview you from a lawyer in a room with a court reporter, and you're sworn just like if you went to court.
Right, just like raise the hand to the square and tell the truth, right? So I
was a little disappointed when I first became an attorney they didn't bring in the Bible. Like, I used to always think, I think a lot of people, and I've had this question from people, will they bring in a Bible and have them like swear on the Bible? I think some states still do that, but we don't do it in Utah.
Do you think
obviously.
That if you don't swear in the Bible, then some people maybe don't tell the truth?
I don't think that. I don't. But I'm just saying, I've had a lot of people like, oh, did they bring in like a Bible or scriptures? And I'm like, no. But at the time, I remember thinking like that you would swear on like not a stack of Bibles, but that like there was some sort of Bible involved.
I wonder, like, have you ever seen anybody do that and then like have their fingers crossed like behind their back?
Yeah, like, look, he raised his left hand up and not his right
maybe,
hand.
I'm sure it happens, maybe. And honestly, I'm convinced that I think some defense lawyers coach their witnesses pretty well on what to say and not what to say. So anyways, so discovery, okay? You're gonna likely have your deposition taken, and you get to do what's called interrogatories and production of documents. That's where you get to get all the corporate documents. So in this particular case with Liebeck or Stella Liebeck, right?
I love the Stella.
They did a bunch of discovery, and they identified documents that McDonald's had received about 700 complaints of the coffee being too hot prior to this incident.
Yes. 700 burns.
So that's significant because what it does is it shows that McDonald's knew about it and they just kept sweeping it under the rug, right? We don't care. We're going to keep doing our water at almost boiling temperatures and injuries be damned, right?
And as I recall, there's even, and again, if I'm wrong, we'll issue a correction, but as I recall it, there's also something in there that was like, if we lower the temperature of the coffee, people will get more refills because they can drink a bunch of coffee quicker.
Oh, drink it faster, yeah.
And so there was something to that, I recall, of if we keep it this hot, they won't be able to get as many refills and we'll save a bunch of money on it.
Because it'll take 3 hours to drink
when you go into McDonald's with a drink cup, you get as many refills as you want, but not if it's so hot that you can't do a refill.
That's, you know what? It might be that's what happened.
Yeah.
And I think that's probably what it was,
I think that was something to discover. And maybe it was just something
when that
they got
came out.
Yeah, maybe when they got someone to admit it. I can't remember the exact context, but it was something like, hey, if we make this so hot that people can't do refills, we'll save a bunch of money on coffee and still be able to charge the same amount for what our cup of coffee is. And so that was one of the reasons for keeping it really, really hot.
Well, and I think the jury found that. So and saw that and saw through that. So despite knowing and being aware of the burn risk and the bottom line, right? Because that's what big corporations care about, the bottom line. They continued to make their coffee as hot as it was. And so the jury saw that. And the jury awarded $200,000, okay, for damages, which apparently they reduced to $160,000 for some comparative fault. Now, that's important too, guys, if you're listening and watching. A lot of times what insurance companies will try to do is, even though they have fault and culpability in causing injuries, they always try to put some apportionment of fault on you.
Yeah.
Right? If she hadn't put it in her lap, if she spills it, it doesn't go into her lap, right?
Yeah.
And it spills like over the floor or on a counter or whatever.
Yeah.
So that award was reduced a little bit because they did put some negligence on her.
Yeah.
Now, the kicker was the jury found that there was a punitive element, or punitive damages were awarded.
Yeah.
And that means where they wanted to punish McDonald's because of the 700 previous complaints.
And I just confirmed it while you were talking. I confirmed that was part of it.
That was part of it.
That was part of
so
it.
So trying to protect their bottom line.
Because they were trying to violate their own refill policy was what the term was.
And save a buck.
Yeah.
So then the jury saw through that and awarded $2.7 million in punitive damages. Now, it's interesting because as we're preparing for the show, for whatever reason, I've always thought it was $10 million.
Yeah.
Did you think that?
Maybe, but only because I know me and you, we talk about this with clients sometimes. So maybe we just rounded it to 10 million just because that's an easy round number.
Where did I get 10 million? I don't know. For years, I thought it was 10 million. Anyways, not 10 million, 2.7.
2.7. And where they came up with that was the equivalent of what McDonald's made on 2 days worth of coffee sales.
That was it.
That was it.
So great lawyering by those lawyers.
And maybe it's like adjusted for inflation now. Maybe that's where you're coming up with it.
Maybe I saw that. Yeah, maybe it was. Because I saw another number adjusted for inflation now, it would be like 5 or 6 million.
Oh, so maybe it's.
So I don't know where I got 10 million. But anyways. So then,
maybe it was that time you caught that like 8-inch fish and you were like, it was 13, 14 inches.
It was 14 inches. It was. I'm not a big fisherman. I'm not.
What's the biggest fish you've ever caught? Because you've obviously caught fish probably before.
Like this big.
Yeah.
Like 3 feet, 4, 5 feet.
Had like a 10. Sword as a nose and
20 feet.
Yeah, 20-footer. Maybe that's how you got to 10 million.
Yeah, it was like really quickly. It went from 2.7 to 5 to 7
Can
to
you believe
10.
this? 10 million.
I don't know. But I'm not a big fisherman.
Yeah.
I don't like it. I like to go catch them and then I reel them in and I see their little faces and I'm like, oh, poor little guy. And I try to get rid of it.
Yeah.
So we got some new information.
4.9 million.
For inflation. Okay. Who knows where I got 10 million. So then even then, what happened is the judge then later reduced the award down to $640,000 because the judge felt it was excessive.
Yeah.
Okay.
And some of that, as we know cases, there's a Utah case out there that's a big verdict against State Farm, and same thing, the Supreme Court made some, basically, if you haven't asked for it and you haven't justified it to the jury and the jury kind of got inflamed and all these other things, that's a whole other episode, but they can reduce those judgments down.
Right. And that happens a lot.
And then McDonald's appealed that and they settled for an undisclosed sum, which my guess was even less than that.
Yeah, it's probably what happened.
Saving some of the appeals costs.
Right. And so that happens all the time. I mean, of course, as a result, you have all kinds of, from both sides of the aisle. When I say both sides of the aisle, meaning like plaintiff lawyer reform and then tort reform.
Yeah.
Thinking that was excessive, should have never happened against this corporation. And then...
Well, and we know this from, a lot. If you go back and look at the medical malpractice cases, for example, that was one where they were very successful. Most of our caps on damages across the country really started post 1994 McDonald's hot coffee.
Right.
Hey, we got to cap this. These are lawyers this lady spilled coffee on herself, right? And you had other people saying, wait, this is corporate greed and all these other things. But I think that was a big push for the caps on damages that really emerged in the 90s and still is present today.
And it's still an ongoing issue, these cap issues and med mal issues, different things in tort reform, right? Yeah. So, I mean, lobbyists make their money for a reason, and that's exactly what they try to do. Now, hopefully it did create some public safety, and McDonald's did a better job on reducing their coffee temperature. Better cups, better lids, a number of things, right? That's the whole idea behind what I think most plaintiff lawyers are trying to do. One, we try to advocate and protect our clients. And two, there's got to be some sort of, safety measures that are installed were implemented as a result of
now there
a
are
bad
some
actor.
Now this is where let's pick on some products liability attorneys at this point. Do you ever see the warning labels on certain things and you're like, well, duh, this shouldn't go in the bathtub?
Right.
Like on the hair blower. There's some of those that I think the public goes, wait a second, did someone do this? And that's why they now have the warning label? Or was this just the defense attorney that works for the company or in-house counsel saying, hey, just in case, we got to kind of imagine every scenario. Let's make sure we put
I think to some degree it's probably as a result of
a little bit of both.
Something happened, and then and good on the lawyers, they demanded change.
Yeah.
And so there are warnings, because that oftentimes happens when there's not a warning.
Yeah.
And so some people just can't appreciate the hazard. And that is true. I don't really like insurance companies, but that Farmers commercial, when you have all the different events that happen and they've seen it all or whatever. I don't know how it goes exactly, but I'm sure they have seen it all, right? They have all the data.
They've seen every type of case.
They've seen almost every type of case out there. I would imagine a lot of that is from maybe even their own lawyers too. Like you said, hey, we got to do a better job.
Risk management's in here. We've got a bunch of suits about this. Maybe we need to put a warning label to help people out.
Right.
I'm sure it's not one-offs. My guess is it's normally not just a one-off. It's repeated complaints or similar type of product.
You would think.
Yeah.
Anyways, if you're watching at home, please, and you have an injury case at the moment, wherever you may be, make sure your lawyer is doing all the things that they need to do to make sure they do proper discovery. They're doing the depositions. They're getting the interrogatories out. They're doing the request for production of documents, and they're getting all the information. Yeah. They're deposing the corporate representative.
Yeah, that's
a 30B6 depo where they come in and say, yeah, we were trying to protect our bottom line and we were trying to prevent refills from happening.
Yeah. No, and I think too, like, a lot of people think during discovery, I'm going to get deposed, and that's all my lawyers are doing. But hopefully your lawyers are being very proactive, kind of on the offense, not just defense.
Right.
Let the defense attorneys be on defense. Plaintiff's lawyers should be actively going at it. And if you have a case that your lawyer's not doing all those proactive steps to put them on their heels and find out those kind of things, then, it might be time for a change.
Yeah, it may be. And to reference the great Mike Alder, a leopard never changes his spots. And so those defense lawyers know if you're going to be proactive or not.
Yeah.
They know if you're going to go on the offensive and take those depositions and do those 30B6 depos and send out those interrogatories and requests for production of documents. They know that. Yeah. So if you're not doing that, or your lawyer's not doing that, you might, want to maybe consider a change.
Yeah.
So,
or at least make sure it's part of the conversation.
Or makes part of the conversation. So, okay, now fast forward to 2025, okay? Similar case, and crazy enough, Starbucks.
Let's get the tea on the hot tea case.
Let's get the tea on the hot tea. I love it. This verdict just came down, I think, March 6th of this year, okay? Yeah. Great trial lawyer, Nick Rowley, $50 million verdict against Starbucks. $50 million. And before we kind of get into the tea of the hot tea case, what do you think? I'm just blown away that in 1992 to 1994, I think the verdict came down in 1994, goes from 2.7 or essentially what, 3 million, right? Because it was compensatory of 200 and 2.7 punitive. So let's call it 3 million.
Yeah.
We go from $3 million in 1994 to $50 million in 2025. Inflation?
I mean, inflation counts for some of it. Inflation would probably be the 10, right? I know we figured out the adjust for inflation at 5.
Just the change, people's perspective,
I think
money.
There's a change.
Well, I mean, inflation, let's be honest, right?
Now this is also Albuquerque versus
LA County.
LA County.
But let's talk the inflation real quick. A gallon of milk in 1994 cost $2? $1.50?
My mom was buying that milk back then.
And a gallon of milk today cost $2?
$3?
$3?
Not enough of a change to
not
account
enough of a change
for the difference.
So a lot of things haven't changed in our lives that would say, okay, that would make sense for inflation, right? But in 1994, a house cost $150,000, and now that same house might cost almost $1 million, depending on where you are, of course.
Yeah.
So that's changed quite a bit.
Some of it makes me think, though, that just the demographic that you get in an LA jury, it could be anything. I mean, this is the same area that acquitted O.J. Simpson. You could get the right jury, probably weed out a little better than maybe a jury pool in Albuquerque. I don't know enough about Albuquerque
I just think money's changed. And think people's Like, we live in a totally different world in 2025 than we did in 1994.
I mean,
with cell phones, technology, cars. I mean, I just saw on ESPN today, Vlad Guerrero Jr. I don't even know if he's that good. I haven't really been following baseball. His dad was great, but I don't know if he's that good. He just signed a $500 million contract with the Toronto Blue Jays.
Yeah.
$500 million.
It's a big number.
That's crazy. In 1994, no one signed a contract for $500 million.
Nope.
So there's got to be some form of thinking in today's day and age that money is just not what it used to be.
Yeah.
We all know that. So even though maybe the cost of a gallon of milk's not changed that much, if you go to the grocery store, it's changed quite a bit.
Well, and I wonder if this is kind of that general theme of like people are kind of upset with the status quo. And I think some of that probably plays into a verdict this
What do
big.
you mean? Like what?
Just how things are going. I don't think some of these big corporate entities are getting any love. Like maybe McDonald's got a little bit back in the day. I think now like a company like Starbucks.
Oh, because back in the day it was Ronald McDonald, right?
Right. It was like,
cute clown.
Cute clown. My kid's playing the play place.
It was a great play place. Yeah.
Yeah. I think that has changed to where I don't think people have that same love as like, oh man, Starbucks, they got my back. They're like, no, I paid like $7 for a coffee.
Even though people do love Starbucks.
They love their Starbucks, but I don't think people are like, we love Starbucks corporate as the brand. And like, they've done some union things that are very unpopular. So I don't think there's a lot of companies out there that kind of get the hate from both sides.
You're absolutely right about that. But I was just in Seattle in July. So what, 7-8 months ago?
Yeah.
And to go to the original Starbucks, we were in line for that original Starbucks, I don't know, an hour. It was
like going to Disneyland or something.
It was crazy. So people love their Starbucks. I get it. But you're right. I think there is maybe we don't have that same connection to
the corporate entities. And
I don't know if you're watching the whole Tesla thing. I don't even know, like, if you bought a Tesla before the Trump presidency, where were you? And if you have a Tesla now, where are you? I don't get it.
Yeah.
But anyways, so
I just think that has shifted a little bit too. I think you nailed it on the head with your first point, which is we all know that the value of it, like hearing now, and I think most people would agree, like when they hear that award was less than $640,000 for skin grafts and all of these other things,
surgeries,
you're like that's outrageous.
And probably sexual dysfunction. I mean, a number of things, right? I mean, sweet Stella at 79, right?
Yeah, there's no way that nowadays that people know the value of a dollar maybe a little better. I think and maybe it's even just as the middle class feels more squeezed on certain things, maybe it's like, hey, we appreciate the value of a dollar a lot more, that something this crazy to happen to you is worth $50 million.
Yeah, and that's where it's mind-boggling. But so let's get into it a little bit. Okay. So it's LA, right? Yep. So what happened was we have a DoorDash or Uber driver that was picking up hot tea or coffee from Starbucks.
Michael Garcia. And the Starbucks employee, you can see, and there's video of it, you can see her handing out the tray of drinks. 3 venti-sized hot teas.
So I think that's 16 ounce.
What's venti size?
I think that's 16 ounce.
16 ounce?
No, that's bigger. I think venti's 20 or bigger. I think the grande is 16.
Okay.
So big drinks.
Big drinks.
And she hands it through the drive-through window. He receives the tray, so he's able to get the tray.
Yeah.
And he brings it into his car. And I think as he was shifting in his car, you can see in the video that the drinks spill all over him.
Well, it looks like here too, at least one of the cups maybe wasn't quite secured into the little, what do you call it, cup holder.
Into the cup holder. And that may have like started the cascading effect of the fall.
Maybe that's somewhat of a difference between, again, if we're going to contrast that with McDonald's, maybe they felt like her spilling the coffee on herself versus this one, maybe one wasn't secured as much.
Right, maybe had some more employee responsibility versus...
Yeah. Like if the McDonald's employee had spilled it on Miss Liebeck, maybe that would have shifted
a little bit. So anyways, we have so he's got it in his car, tea spills all over his lap, same type of thing, 3rd-degree burns, surgeries, grafts, sexual dysfunction, a number of issues, right, that he's dealing with.
Thighs, groin, buttocks, everything, the full works of surgery.
And I think it was the same type of temperature, 180, 190 degree temperature, hot tea, and $50 million verdict. Now, what's interesting about this case, and I think what's maybe unique or a little different than the McDonald's case, Well, similarities first. First, I think Starbucks offered $3 million.
Okay.
Okay. And
and maybe that's a lesson learned from we shouldn't do $800.
right. Like they offered 800, it didn't work out. $3 million. And I think that was rejected. Do we have any information about what was offered or what was demanded? I'm not sure what was demanded, but anyways, $3 million was rejected and they filed suit. Okay. And unlike McDonald's, I'm not sure if we have a bunch of discovery yet in regards to what they discovered and what I think Starbucks also knew of the issue about how hot their tea was and had a number of complaints. And so I think that was part of it. But just prior to trial. So after discovery and after going through all the depositions and requests for production of documents and getting all the information, Starbucks had offered $30 million. But here's the kicker. Starbucks wanted a confidentiality agreement in place.
Okay.
With the $30 million offer. Okay. So Starbucks said, look, we'll offer you $30 million, but we want this.
We don't want you to be able to claim that we paid anything or that there was any type of victory by the victim.
Or that we did anything wrong. But Starbucks offered 3 and then they increased their settlement offer to $30 million, but they demanded the confidentiality.
Well, apparently he agreed to the $30 million amount.
But no confidentiality.
Well, but under the condition they apologize, change their policies, and issue a memo to all their locations to double-check their hot drinks.
So apology, and I've been kind of following a lot and seeing a lot of different things on it, and even I watched a video from Nick himself.
Yeah.
The confidentiality was a big issue.
Yeah. I would guarantee.
And for public safety and changes in policy and procedure and accountability, they said absolutely not.
Well, they wouldn't be able to with confidentiality being the sticking issue.
So they said absolutely not. And I think even Nick said that he was willing to go and they're prepared to get less.
Yeah.
But at least people would know. And so they took it to trial. And of course, the verdict comes back at $50 million.
Well, and I feel like,
which is amazing.
After this has come out, as I recall, and we studied the McDonald's case in law school, it's a great example of kind of how the public sentiment was really negative with the McDonald's case. I feel like it's a lot more mixed I haven't heard as many people outraged. I feel like a ton of the stuff is like about the temperature of the drink this time, as opposed to the narrative isn't this so outrageous for someone spilling coffee on themselves? Like, I feel like that was probably the prevailing narrative with caps on damages and all of that stuff versus now.
I did see quite a mixed bag of comments, right?
Yeah.
In the TikTok and Instagram
but it hasn't
posts.
felt lopsided against the victim.
It hasn't. Well, no, because it's been one comment, that's excessive and crazy, and the other is like, good for you. I mean, It kind of went back and forth on the range of the comments. But this is one thing I think I find interesting about social media and the day and age we live in. It's almost like yesterday's news.
Yeah.
Like, it's almost like, next?
There was that $50 million verdict. Like, what else?
What's next? And
that's true.
And I'm glad we're talking about it because I think it's something important that people need to be aware of. That, and you've got these amazing lawyers that are fighting for justice, and they're holding these corporations accountable.
Well, and this one hit big against Starbucks and the PR. Like I said, it's been both sides. But me and you go to conferences where we meet with these lawyers that have had really big verdicts. We sat with a lawyer one time. I always remember because he was a ginger lawyer. So, shout out to the redheads in the world. It was a $72 million.
Jay Vaughn, right, from Kentucky.
Or 78. It was in the $70 million range. Did not get near the news of this case.
I don't think I got any of it. Yeah. Maybe in the local.
I mean, we hadn't heard of that case. I think it was Indiana or.
I think it was Kentucky.
The company, it was against an asphalt company, I recall. But not near there wasn't hundreds of TikTok videos, and I don't know if TikTok was as prevalent as it was at that conference. But still, this case, because it paralleled that McDonald's case, I also feel like it helped amplify it. To some degree.
And it is Starbucks, right? I mean, if you're a coffee drinker, you have to live literally under a rock if you did not know Starbucks.
Yeah.
So it's a big deal. It's super relevant. It's the corporate world. It's big verdicts.
But this seems like, to those people listening, that $50 million is to the people that are like, this is outrageous. There's a lot of $50 million verdicts out there. I mean, this isn't the only one.
Right.
But this one for sure got the national attention.
And of course, to Starbucks is now saying we're going to appeal it and it's injustice and blah, 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 blah. Right. But in that one that you referenced with Jay out in Kentucky, I think it was in Kentucky, they paid it.
Yeah, they paid it.
They paid it.
In fact, the conversation we had was like, because, one of the big worries me and Tyler have about some of these bigger verdicts is, okay, did you get a verdict against someone that has no money or the company's filing for bankruptcy? I think the conversation we had with him is like, hey, how'd that go? We just heard the cool part of the case. And he was like, I think he said the final check cleared.
Well, it's not a worry. It's just when you're fighting for your clients, right? You're fighting for, I think the biggest reason is to get justice for them.
Yeah.
Right. And the best way and the only way that we as civil plaintiff lawyers can get justice is in the form of money.
Yeah.
Okay. So let's be honest, right? Michael Garcia, does he care about the policies and procedures of Starbucks moving forward? If he does, good on him.
Yeah, he's the white knight victim.
I mean, if he does, that's impressive.
Yeah.
And I hope he does to some degree, because that just means that he's an honorable person and he's going to take his pain and issues and permanent
and trying to help other people.
And so there's silver lining to
it.
Like
a righteous justice to it.
Absolutely.
Yeah.
But I also wouldn't fault him if he's like, okay, that's great, but that doesn't pay my medical bills.
Yeah.
That's great, but that doesn't compensate me for what I'm dealing with the rest of my life. And that's awesome, Nick and team. Go do what you got to do, but what do I do about this?
Yeah. No, and don't you feel like we have this conversation with clients a lot, though, where this is the reason a lot of cases settle hey, me and Tyler would love to take this case to trial and go try it in front of a jury and love to get a big verdict. But at the same time, you have that risk of getting nothing. And Nick Rowley is a little bit of a different ball game. And I'm just going to say it. He's
trying cases all over the country.
He's trying cases all over the country and, kind of gets to probably pick and choose to some degree what cases he takes, which ones he doesn't. And I think he's a great lawyer.
Rightfully so. I mean,
rightfully so. He's got a great track record. But I think me and you have that conversation sometimes of like, can you risk it all? And I think there's been some cases like, again, if McDonald's top offer the whole time was $20,000, you had nothing to lose.
Yeah. And in that analysis, you're like, let's take this to trial.
Yeah, let's take it to trial and go big and hope for the best. And we've seen that on some recent verdicts out of Nevada I think we talked about in the last show there's another one that was in the 28 million range or something like that the initial offer was rejected for 50,000 or something, or it was a lower number.
30 million, that the offer that they made pre-trial, that, to be honest, that'd be hard to walk from.
That takes guts.
From and saying to your client, you might get less or you might not get anything.
And again, to be fair to that client, maybe there was a little bit more like, hey, if they're not willing to take responsibility and there's an offer of 30 million on the table, maybe that client was the white knight
maybe
victim.
He was.
Maybe they
were. I'm not saying he wasn't. I don't know. I'm just saying that would be extremely difficult to walk from.
Can you imagine even as the attorney counseling your client? Because so many clients are like, look, Tyler, and I've heard this 100 times on the phone, Tyler, I trust you. You tell me what to do. And you're telling your client, and again, maybe they've done enough sampling to know that this was going to be 50 million or they knew, but can you imagine telling your client like, look, don't accept the 30 million. It has to be that client to some degree wanted that righteous justice of, hey, I got to do this for everyone else that's so hard.
Or, he's like, hey, we'll pay the 30 million if we get anything less. Don't worry. I mean, I don't know.
Would you be willing to tell your client like, look, you might get zero, you might get nothing? They had to have known, again, from mock juries. So again, I'm not saying that they went in blind.
They probably felt really good about it. Obviously, there's an offer for 30 million on the table, but that's just, I mean, again, it's such a fine balance of weighing what's best for your client and what you think is white knight, public service, fight for justice, which is what we're doing.
Yeah.
It's just very difficult.
Yeah.
Because now, for example, Starbucks is appealing, and that appeal might take a long time. And so Mr. Garcia may or may not see any amount of money for quite some time.
Well, and we'll have a whole different podcast if that gets overturned on appeals, right?
Absolutely, because then we're going to dig into what happened, why they overturn it.
And that they could have settled for 30 million.
Right. So then, and I'm not saying that what they did was, I applaud it. I think it's amazing. It's just it's such a balance that what we're doing for our clients, and to reference Mike Alder again, an also amazing trial lawyer. I think, and I could be wrong, but I recall him saying he's gotten several verdicts of 8 figures, right? Of which I don't think, and I could be wrong, but I recall him saying of those verdicts, he hasn't collected any of that money.
Yeah, or the full amount of it.
Yeah. But on the flip side of 7 and 8 figure settlements, he's received all of it.
Yeah.
And that's because in the form of a settlement, they're paying. And then you've been able to then compensate the client for the injustice they've endured.
Yeah.
And I would argue still there's public policy change, because part of a lot of those agreements, you're saying, look, that's got to change. That's got to change.
Yeah.
Warning labels have to be added. This has to be done.
Well, and their insurance carrier doesn't pay out $30 million without there being some change. Right? So even if they would have been confidential, it would have affected change, but maybe not to the degree that they were happy with or satisfied with.
Right. So again, I applaud it. I think it's amazing. It's an amazing verdict, and Nick Rowley and his team should be and they are. They're getting the accolades and they deserve them. That's where I struggle in regards to, okay, 30 million, but then again,
well, and me and you,
it was with confidentiality, and there wouldn't be change, and Starbucks wouldn't be held accountable. So it's a great result.
Yeah. And I'll add this too. We've been to conferences before, and you're trying to learn from, it's kind of a group mentality of, hey, this is how I did this. It might not work. But you'll hear them say like, yeah, and I had got no cause in that jurisdiction 2 times before. And I'm like, what was the settlement offer on the table prior to that no cause? It's one thing if we've got no risk. Hey, we're offering peanuts. Me and you had a jury trial that I feel like they never offered any real money. It was the easiest decision to say, let's go forward and let's go fight this and do everything we can to get our clients even reasonably compensated. Not $50 million. It wasn't a $50 million case. But in that same vein, some of these trial attorneys, it's almost like, hey, I don't know if they had that conversation with that client, because when they say that they got no cause twice before in that same jurisdiction, I'm thinking, okay, was that one where the client was willing to roll the dice? What was the information? Because it is a lot of risk.
But on the flip side, if you're Nick Rowley and you see it, and you've been through you have all the discovery, and so you feel comfortable knowing that verdict is out there and it's available or it's likely, why not? Because Vlad Guerrero Jr. just got $500 million for playing some baseball. And like, look, I love baseball and I get it. And I mean, the big TV deals, but $500 million? If that guy doesn't have 10,000 home runs over the next 10 years, is $500 million worth it?
And obviously to their team, it was totally worth it.
So then it's like, well, freaking jury of LA County, why didn't you guys do $100 million?
Yeah.
So it's such an interesting issue. And
and to be fair to Nick Rowley too, it's probably a little easier for him. I mean, how many 8-figure settlements has Nick Rowley had?
I'm sure he's got, it's every
25 to 50, 100 of them.
He's posting something all the time about how recent settlements and verdicts. So, it's great legal work, but that's where, if you're watching and listening to the We Win Injury Law podcast, it's time's changing.
Yeah.
And money is viewed differently. And when you have life-changing injuries like Stella, sweet Stella, Granny Stella, and Michael Garcia, there's got to be justice for them, and that is in the form of money. And just as we've seen from 1994 to 2025, from 3 million to 50 million, if something like that were to happen again, and hopefully it never does, but to someone else in 2035, will it be 100 million?
Yeah. Well, I think you've even had a defense mediator, but defense mediator even told you like 100,000 is the new 25,000.
Yeah,
things are changing even in, I'd say in the last couple of years, things are changing.
So when we ask you guys for money, and you're out there, and you're like, what's fair? What would you take to go through that? What would you take to have sexual dysfunction for the rest of your life?
Is there a number, Tyler? Is it anything less? Would you take any less than 50 million?
That's an awkward question.
30 million sounded good to me. I would have taken 30 million.
I don't know. 50 million doesn't seem enough. So, that's where
it gets rough.
And I think at trial, they did ask for like 100-something million. I think if I recall from what I read, and maybe the jury said, hey, it's not 100 million, but it's 50 million.
Yeah.
I don't know. Vlad Guerrero Jr., 500 million. No disrespect, Vlad Guerrero Jr., but
this verdict,
yeah,
right?
yeah. So I read that today.
Maybe that LA County would have been like, you know what, 500 million.
All I know is for 500 million, Vlad Guerrero Jr. better be hitting like 500 and have an on-base percentage of perfect. $500 million. That's where I'm like, and even today, we were in mediation this morning. We couldn't even get 20 grand out of this insurance company for significant back injuries to our client.
Yeah.
And we said, pound sand, we're gonna keep going down this path of trial.
Yep.
And they hem and haw like it was like we're offering like the moon.
Well, even the mediator, you have doubled their previous offer of $7,500. And I thought, double what? It's still garbage.
It's what? Yeah, double. Okay, so
And the client's not stoked.
So you're like, okay, it's what's poop times 2?
Yeah. 2 shits.
Like, give me a break. Like,
you know
come
what?
on.
It felt like the insurance company couldn't give 2 shits about that case.
They didn't.
I like
They
that.
don't
I like
care.
that analysis.
And that's why we are doing this podcast. That's why we do what we do. We're talking about these things so that hopefully you watching and listening, all 5 of you, are like, you know what? Keep doing what you're doing. And if we ever get called to a jury, we get it.
Yeah.
How much do you want?
Yeah.
That's really what it boils down to.
After you've proven your case, how many zeros?
Because that's, at the end of the day, it's what we want to do. We want to win for our clients, period.